You started with standing, which is the really logical place to start. It's usually the first question I ask people when I interview them. How did you even get into court? And I noticed that this was the topic of your first class. So you were also kind of introducing the whole course to your students. Can you tell us a little bit about how you approached it? Both, I mean, since you're talking to students, they don't understand that much about standing. I mean, they've taken common law, but standing is usually not the top issue on people's minds. And then helping them understand like how crazy standing is when it comes to animals and thinking of some ways to deal with it.
Yeah, so first thing I did when we talked about standing was, to note that one need not be a human being to have standing. So all sorts of artificial entities like corporations, municipalities, organizations have legal standing. And there is case law in some of the lower courts that allows for animals to have what's called Article 3 standing, meaning that they have standing so far as the Constitution is concerned. And then the harder question is often, do they have any rights that give rise to a cause of action that allows them to sue?
Yeah, so you got into the problem of not just whether animals could have standing theoretically, but when laws are passed to protect animals, humans are sometimes held not to have standing because the law wasn't meant to protect them, and animals are held not to have standing because they're animals. So it ends up with no one having standing.
Right, right.
Uh,
Is the humans either don't have standing or they don't have a cause of action, right? There's this
right.
technical difference. Yeah,
Yeah,
yeah.
yeah, which sometimes they call a statutory standing. It's the most confusing use of language. I much prefer to call it a cause of action. Yeah.
The Naruto case is a
Yeah,
good
tell us about
example.
the Naruto case.
For listeners who don't remember, Naruto was this monkey who took a selfie on this camera that this guy had set up in the natural habitat. And then PETA, on behalf of Naruto, brought a lawsuit against the photographer, saying that the copyright belonged to Naruto, not to the photographer, and therefore the proceeds from this photograph, which is an adorable photograph, ought to go to I think it was for a monkey sanctuary or something. They weren't going to have Naruto use it personally. The Ninth Circuit assumed, because there was prior case law in the Ninth Circuit, that Naruto had Article 3 standing, but then said that the Copyright Act didn't give him a cause of action and didn't give it to PETA either. And so that's how they get rid of it. So there's always, when I teach federal courts, I often tell my students that if they end up practicing in this area, I say this specifically about habeas law, but it's true about a lot of public interest litigation. You can choose between whether you want to do good or whether you want to win.